In other lectures, we've talked about legal causation, the legal significance of consequences, and legal responsibility for failures to act. We turn at last to the subject of mental states. We're going to focus on the role of mental states in the criminal law, although mental states play an important role in civil trials as well. A criminal statute defines a crime as a set of necessary and sufficient elements. I'm going to use the Model Penal Code, or MPC, as the basis for this discussion. The MPC is published by the American Law Institute. It's not the actual law of any jurisdiction, but it serves as a model for states to consult when drafting their own criminal codes. Under the MPC, there are three types of elements: conduct, attendant circumstances, and results. Consider the MPC definition of the crime of indecent exposure. A person commits a misdemeanor if, for the purpose of arousing or gratifying sexual desire of himself or of any person other than his spouse, he exposes his genitals under circumstances in which he knows his conduct is likely to cause affront or alarm. This definition illustrates all three element types: conduct, exposing your genitals; result, arousing or gratifying sexual desire; and attendant circumstances, those in which you know your conduct is likely to cause affront or alarm. We'll discuss each of these three element types. Every criminal statute has a conduct element, but simply performing a criminal act in and of itself isn't usually enough to make you guilty of a crime. Some elements, including conduct elements, must be accompanied by a culpable mental state. This requirement is historically referred to as the requirement of guilty mind, or mens rea, which in Latin just means the mental thing. Modern criminal codes specify mental states with respect to each element of the crime. The three mental states are purpose, knowledge, and recklessness. An actor can have any one of these mental states with respect to any element. An actor has the mental state of purpose with respect to a conduct element if and only if he intends to engage in specified conduct while aware of its nature. Picture a man, call him Hector, who intentionally removes his pants in public. If Hector sincerely believes that he is wearing a swimsuit underneath, then he doesn't purposely expose his genitals, even if he does in fact expose them. Whereas, if he knows that he's naked under his pants, then he purposely exposes his genitals. Now let's consider what it means to act purposely with respect to a result element. An actor has the mental state of purpose with respect to a result element, if and only if he has the conscious object of causing that result. The indecent exposure provision of the MPC mentions a result of sexual arousal. An actor has purpose with respect to that element if and only if it's his conscious object to cause sexual arousal. It's not enough merely for him to believe that sexual arousal will occur, even if he's certain that it will. That's merely knowledge. It's not purpose. An actor has knowledge with respect to an element if he believes that it exists, or, in the case of result elements, if he believes with practical certainty that it will occur. An actor can have knowledge of a result element whether he's pleased, displeased, or indifferent toward it. By contrast, he can have purpose with respect to a result element even if he thinks it's unlikely to occur. Although he must want it to occur, it must be his conscious object, and he must believe that his conduct makes the intended result at least a bit more likely. The indecent exposure provision of the MPC also specifies attendant circumstances, those under which the actor knows his conduct is likely to cause affront or alarm. What sort of element is this? The MPC defines recklessness as conscious disregard of a substantial and unjustifiable risk that the element exists or will exist. The indecent exposure provision doesn't specify that the risk is substantial or unjustifiable, but it otherwise reflects a recklessness standard. The actor can be guilty if he believes his conduct is likely to cause affront or alarm, even if causing it is not his purpose and he's certain that it will occur. Let's get back to Hector's story. Expecting to be alone, Hector plans to drop his pants and masturbate at noon on the deck of his boat. When noon arrives, he sees a family sailing nearby. He is chagrined, not wishing to alarm anyone, but he proceeds with his plan. He acts recklessly, despite lacking any purpose to alarm. Whereas, if Hector fails to notice the family and sincerely believes that he is alone, then he is not reckless, even if his exposure alarms them. There are many questions concerning what makes an actor reckless with respect to an element. The test has both objective and subjective components. The actor must be subjectively aware of the nature and magnitude of the risk. Imagine a guy named Marvin who mixes chlorine bleach with ammonia in his office. He intends to create a refreshing smell and mistakenly believes this to be a safe combination. In fact, he runs a 50% chance of creating toxic fumes that will injure his coworkers. Marvin's not reckless because he believes that he's running a risk of less than 0.0001%, and such a minuscule risk is not objectively substantial. Imagine instead that Marvin knows of the 50% risk of injury, but genuinely believes that such a risk is not substantial. This is hard to imagine, but perhaps he believes that everyone likes to live dangerously. Despite this belief, Marvin is reckless because he believes that the risk is 50%, and such a risk is objectively substantial. Or perhaps he believes that a 50% chance of injury, albeit substantial, is justified by his goal of refreshing the air. Again, he's reckless. A 50% chance of injury is not objectively justified by his trivial goal of freshening the air. Interesting philosophical questions now arise. Suppose Marvin knows that mixing chlorine and ammonia creates a 50% risk of injuring others, but he mistakenly uses water instead of ammonia, diluting the chlorine harmlessly. Does he act recklessly? Some theorists argue that he does, but the law is not settled. It's also hard to know what substantial risk means in practice. We don't lead our daily lives consciously quantifying the risks of our many decisions. When I drive through a red traffic light, I know I risk crashing, but I don't know if that risk is 10%, 1%, or 0.001%. When I serve my guests raw oysters, I believe there's some risk that they'll become ill as a result, but I can't put a number on it. Some of my actions seem dangerous to me. Most don't seem dangerous. Rarely are my thoughts more precise than that. The law doesn't expect actors to have quantified probabilities in mind. However, the actor's subjective awareness of the magnitude of risk is relevant. Finally, you might wonder whether the substantiality of a risk is fundamentally independent of its justifiability. Even a substantial risk can be justifiable in the right circumstances. Suppose a sharpshooter fires a rifle at a fleeing suspect in a crowded park, running a substantial risk of injuring a bystander. If the target is a suspected terrorist, then the substantial risk may be justifiable, but not if he's merely a suspected shoplifter. Conversely, one might wonder whether even a minuscule risk is justifiable if the actor takes it for bad reasons. Suppose Nick throws a rock at his ex-girlfriend from 100 meters. No one else is nearby. Nick hopes to hit her, but he knows that his chance of success is minuscule. Has he acted recklessly? What if, miraculously, he hits her? Because running this risk is completely unjustifiable, some would argue that Nick is culpable, however small his chance of success. An actor who's not reckless with respect to an element might nonetheless be negligent with respect to it, but negligence differs from the mental states of purpose, knowledge, and recklessness. Negligence is historically classified as a mental state as well, but this is a misclassification. Negligence refers to the risk taken, not the actor's mental state with respect to that risk. An actor is negligent if and only if she takes a substantial and unjustifiable risk. She need not be consciously aware of the risk. Suppose you park your car on an incline without engaging the parking brake, mistakenly believing that the brake engages automatically. You've taken a risk that a reasonable driver in your situation would not take. You're genuinely unaware of the risk, but a reasonable actor would be aware of it. You're negligent. Negligence plays a central role in tort law, but only a peripheral role in criminal law. There are, however, some crimes of pure negligence. The Model Penal Code, for example, includes several such crimes: negligent homicide, assault with a deadly weapon, and criminal mischief with dangerous means. But the very idea of punishing someone for negligence strikes some observers as unjust. After all, if you're merely negligent, not reckless, then by definition you're unaware that your conduct is wrong. How can you be blameworthy or criminally liable for it? Moreover, when you're unaware of a risk, you have no control over your lack of awareness. You're unaware of the risk, and you're unaware that you're unaware. And you're unaware that you're unaware that you're unaware ad infinitum. Only if someone else informs you of your mistake will you be able to avoid it. So it seems unfair to punish you for negligence. All of the objections against crimes of negligence, and then some, apply also to crimes of strict liability. Few crimes fall into this category in the United States, but there are examples. Possession of certain illegal narcotics, statutory rape, possession of child pornography, and a few other crimes. Strict liability means that in principle, an actor is guilty of the crime, even if she's not negligent with respect to any element. Imagine Justin buys a bag of powdered sugar, which unbeknownst to him has been filled with powder cocaine. No reasonable person in Justin's position would suspect this. Nonetheless, if the police lawfully search Justin's bag and discover it contains cocaine, then Justin could be convicted of possession in the United States. He's committed a criminal act, taking possession of cocaine. His mental state's legally irrelevant. That's what strict liability means. This isn't to suggest that in the real world, Justin would inevitably be prosecuted. The prosecutor might believe Justin's story and drop the charges, but she's not legally obligated to drop them, even if she believes him. Strict liability statutes allow for conviction in such cases. Strict liability has some advantages over more permissive standards. By eliminating defenses based on mental state, strict liability reduces prosecution costs and ensures that fewer guilty defendants are acquitted. Accordingly, it deters prospective criminals who'd otherwise bet on winning acquittals by introducing reasonable doubt about their mental state. However, strict liability also generates more false positives. These are convictions of morally innocent defendants, such as Justin. It may also encourage actors to take excessive precautions and to avoid certain socially valuable activities altogether. For these reasons, strict liability remains even more controversial than criminal negligence. You've been assigned a classic paper by Richard Wasserstrom in which he defends strict liability in the criminal law, at least as not being unjust in principle.